Our next case is 2016-859 Cleveland Metro Bar versus Kenneth Ronald Donchatz. Mr. Donchatz?
Thank you, Your Honor. May it please the Court, my name is Ken Donchatz. I know that I've been here countless times as counsel, but today I am unfortunately before you as the respondent. My attorney and I decided that I should come here today to address you directly so that I could answer your questions and to demonstrate that the relator's argument that we did not take this process seriously is wholly unfounded. This was not an easy decision. It took a lot of convincing. But in the end, as you know from the record, we did enter into over 80 factual stipulations, and we stipulated to over 25 exhibits. In our brief, we addressed 3 substantive issues where we believe the panel committed error that we'd like you to review. The first is the failure of the panel to consider any mitigation evidence, including over 20 years of volunteer work, both for this court and to the profession through the Ohio Center for Law-Related Education. The second issue we raised was a failure of the panel to consider our First Amendment defenses that are relevant to the charge in Count 3 related to the Carol Hampton attorney discipline case. And the third issue we raised is the failure of the panel to consider our defense in Count 4 that the evidence clearly showed, and there was no rebuttal evidence presented, that before the actions that were taken in that case, the respondent did consult independent legal professionals who had more experience in that area, and that attorney came and testified. And so those actions were taken under the advice of more experienced counsel. The panel did not even consider this evidence. All of this evidence is important because under the rules and cases that we cited in our briefs, they do provide a defense to the charges in Count 3 and Count 4. But the panel's opinion does not analyze that evidence, it does not mention that evidence, and it does not weigh the evidence. But there's no explanation offered in the decision for why that evidence was not considered. It's just a wholly silent.
So your argument here is more to the sanction, the penalty, than to the finding of wrongdoing.
Well, we did not contest the findings in Count 1 and Count 2. We contest the substantive findings in Count 3 and 4 based on the failure to consider the evidence. But as far as penalty goes, if you consider our defenses in Count 3 and Count 4 and you consider the mitigation evidence, which was ignored by the panel, this would be a substantially different case with a substantially different penalty. And that is the issue we bring to you before today. Unless there are questions, that is all I have for you today. I just wanted to make myself available.
What do you feel would be a fair sanction here?
Well, that's a difficult issue because, first of all, any answer I give you is going to be wholly self-serving, and I'm well aware of that. But I do think that it is unprecedented in attorney discipline cases to look at this amount of mitigation evidence and then not even mention it in a case. It's just unprecedented. If you accept our defenses in Count 3 and Count 4, this case becomes very similar to a case called ODC versus Kimmons, Tom Kimmons. And that was a case where the attorney had an identical Count 1 charge, but he also revealed his client's confidences and then had his client involuntarily committed and then sold his property. In that case, because of the mitigation evidence, you stayed the suspension. And so if you consider our defenses and the character testimony, I believe that you would come to that same conclusion.
What I can't understand is why you would file a satisfaction of a judgment, an official legal document, knowing you hadn't paid the judgment. That is just about the core of deceit.
It was a mistake, Your Honor.
More than a mistake. It's an intentional act.
At the time, it was not intentional, but it was a mistake.
How could it not be intentional? the purpose is to exonerate oneself from an obligation.
Right.
It had to be an intentional act.
I don't remember it that way, Your Honor.
Okay.
I understand your point, but I don't remember it that way.
How do you remember it?
My memory, and I didn't remember the full sequence of events at the time because I forgot that I had communicated with the other counsel at one point. But my memory was that it was paid. We couldn't find that evidence, although we searched far and wide for it, and so my memory must be faulty, but I do have a clear memory of paying it.
You have a clear memory of paying by what means?
A check.
You wrote a check,
Yes,
and the check was never cashed,
that is correct.
never returned to you,
Correct.
never exists in your bank records.
That is correct, yes.
Okay, so when a check isn't cashed, that's pretty telling that the money has not transferred from your account to the intended recipient's account, correct?
Yes, it is.
And when that was brought to your attention, it wasn't too late to check with your bank to see whether that transfer had taken place, was it?
No, it was not. You're right.
And did you do that?
I did not. I went to the court to see if
Why did you not call your bank or look at your bank statement or sit down with your banker and say there's a discrepancy here? Put a trace on this check.
You're right, Your Honor. That's what I should have done. You're
But
correct.
instead, you file a document, correct?
Well, I had filed the document long before that. Yeah, I agree. That's what I should have done. Totally agree.
I've never seen a defendant file a satisfaction of judgment. I mean, is that appropriate at all?
That was a matter of contention, but it has been done. I don't think it's that unusual. There was no evidence that it's inappropriate or that it violates a rule.
Counsel, you're asking this panel for a different sanction that's being suggested by the board. And one question that's not clear to me, I think you're saying that taking the $100,000 loan from a client you today say was an error?
Well, we admitted that conduct, Your Honor. We're not contesting that
fully
particular
understand it.
point.
Has the $100,000 been repaid?
Well, it's been more than repaid, Your Honor, yes.
How so?
They were paid in cash and with a return of an item that they had given me.
Okay, there was a desk that was
Right.
returned, and then
Yes.
$49,000 in cash was given.
Correct.
So you're saying the desk was worth over $51,000 if
Yep.
you look at evidence?
Yes,
I
it
mean,
was.
Interest as well.
Yes, it was.
And is there an appraisal for that desk to show its value?
There was. And then they had access to that.
Who had access to that?
The people who have the desk, they have access to that.
Okay,
They were
explain that.
satisfied. Well, we gave them the appraisal, we gave them the name of the person who repaired it, and
So
they had all that.
the person who repaired it gave an estimate of, or a valuation of this desk of over $50,000.
Yes.
What kind of desk was that?
It was some kind of antique desk. It was very large. It was very old. It was like 100 years old. They didn't want it. They were going to destroy it. They asked me if I would take it and put it in my office, and I said yes. So then I had it restored, and then they wanted it back.
They were going to destroy a $51,000 desk?
They didn't know what it was worth. They had inherited it out of someone's barn, and they thought it was not worth anything. But they thought if it could be used, they would let me have it for my office.
So a certified appraiser said that this desk is worth over $50,000,
Yes, he is the one who also repaired it.
and he's a certified appraiser of furniture.
Yes, and he repaired it. He restored it.
The disturbing part for me, and maybe you want to address it, Mr. Donchatz, is the fact that the first instance with the Davy Tree Company, when the representation was made about the satisfaction and the satisfaction of the judgment, same conduct was repeated with the magistrate during the representation of the story and the Leader Technologies when the consent entry was filed without the consent of the parties as to the representation that the matter was resolved.
It was,
That's a disturbing development for me.
well,
It seems like the same kind of thing. And it was necessary then for the court to vacate a stipulated entry that you had submitted to the court, which is making a false statement to a tribunal.
well, Your Honor, that, I think they're different.
Pardon me, please?
I think they're different, Your Honor. In the Leader case, I did consult with counsel before I filed that.
You did or did not?
I did, and he testified. He came to the hearing and testified that I had consulted with him and that he told me this was the way to do it when we had a consent judgment.
So the defendants consented to the draft judgment entry?
They consented to the amount in controversy, and the magistrate told me to file a consent judgment. When I presented it to the other side, they refused to sign it.
My information is that Mr. Story, counsel for Leader, testified that the magistrate had not requested a consent entry be drafted and instead asked them to put the proposal in writing, and they did not consent to the draft judgment.
Well, the
Am I wrong?
magistrate asked me to put together a consent judgment, and I emailed, you have the emails, I emailed the magistrate and I said, did I misunderstand you? Am I doing this incorrectly? If I did, please let me know and I will do something else. And the magistrate and his staff did not correct me.
Was there any discussion between you and Mr. Story about frivolous conduct and that he had committed fraud on the court?
Mr. Story?
Yes.
I don't recall that.
Okay.
Okay, thank you.
Counsel, I'm sorry, you've raised a question in my mind. I'm looking at the board's report. Where am I getting the number $57,000 has been repaid on the $100,000?
It is in the record. It didn't make it into the report, but it is in the record. It's in the transcript.
$57,000 in cash or check?
Yes, that is in the, it's 47, but it was in the record, yes.
That's why this morning I'm a little bit confused when you say it's paid in full.
Yes.
And the desk that they did own, that they now own, is worth $51,000.
A little higher than that, but yes.
And the people that you borrowed the money from are therefore saying, thank you very much?
No, they settled the case, but they haven't come back and asked for anything else. They considered it satisfied when I returned the desk. That was a big issue for them.
And is there a satisfaction of judgment in that case?
There was never an open case. They came here instead of going to court.
They filed a grievance.
Yes, they did.
So,
But there was no civil action.
right. So, did you return some money and the desk after they filed the grievance?
No, yes, I did. But no. I'm sorry, my
What's the
memory is
sequence
faulty
here?
on this. Pardon me?
What's the sequence?
The sequence is some of the money was returned, then they filed the grievance, then the rest of it was satisfied. That is the
Okay,
sequence.
so
yes.
you were prodded to make some kind of restitution there by the filing of the grievance.
We were prodded to resolve the issue of outstanding attorney fees as well. That was all part of the negotiation that my attorney did with them.
See, counsel, I don't want to belabor, but I'm looking at paragraph 26 of the report.
Right.
And which you're appealing here today. You'd like us to believe otherwise.
We're not appealing the first count, Your Honor. We only filed objections to count 3 and 4.
Well, I'm looking at paragraph 26, which says, ultimately, respondent only repaid the Cracknells $57,000, so I am not losing my mind. The number is 57, not 47.
If that's what it says in the report, that's what it says in the report. I remember paying them 47 plus the desk, but the desk didn't make it into the report either, so.
But you're telling me this morning the 57 with the desk becomes 100.
It becomes more than that.
Okay.
Yes.
Okay.
Thank you.
Thank you.
Ms. Bones?
Chief Justice, and may it please the Court. My name is Sarah Butts, and I'm here with my colleague, Rob Hanna, on behalf of Relator, Cleveland Metropolitan Bar Association. While Respondent would have this Court believe that his conduct is nothing more than sloppy or a mistake, when you look at his conduct as a whole, a clear pattern emerges of dishonest conduct driven by a selfish motive that not only supports the panel's findings, but deserves a more severe sanction. Now, before addressing respondents' objections, I think it's important first to look at what he does not object to. Now, at no point during the grievance investigation, nor during the 2-day hearing, did he ever accept responsibility for his actions. During his hearing testimony, he refused to acknowledge wrongdoing. It was only in the briefing to this court that respondent finally admitted to the rules violations in connections with counts 1 and 2. But this belated acknowledgement is significant because, as this court acknowledged, the violations in counts 1 and 2 involve violations of 7 different ethics rules, including a finding of conduct involving dishonesty or deceit. And by this court's precedent, the violations in counts 1 and 2 alone justify the sanction recommended by the board.
And what is that recommendation?
It's 2 years suspension with 6 months stayed.
Okay. Are you recommending 2 years with 6 months stayed?
Our recommendation would be an indefinite suspension.
Indefinite, that's what I thought. So you're objecting to the recommendation.
That's correct. We do not object to the panel's findings. We believe that they are based on clear and convincing evidence. It's simply the recommendation for sanction. Because when you factor in the rules violations in connections with counts 3 and 4 that the court did find, or the panel, did find were proved by clear and convincing evidence, that demonstrates that a stiffer sanction is justified.
All right, let me ask you, he starts out by saying that his mitigation evidence was not even considered by the panel or the board here. What's your response to that?
My response is that it was considered by the panel and taken into consideration when they came up with their recommended sanction. The report clearly lays out that they acknowledged the fact that he had no prior disciplinary record. And in fact, it was that lack of disciplinary record that they pointed to in suggesting that an indefinite suspension wasn't warranted and then giving him the 2-year suspension. The report also indicates that all evidence and testimony were admitted and considered in fashioning their recommendation. But now I want to address the objections that he raised to you here today on counts 3 and 4. On count 3, the Hampton matter, he mentioned that the court did not consider his First Amendment defenses in the statements that he made in the motion in limine to the board. The panel did consider his First Amendment defenses and properly disregarded them. As the Berry case, which he cites in his briefing to this court, says, opinions are only defensible if they fully disclose all facts. And in this case, respondent acknowledges 3 critical facts that he did not raise in his motion in limine. Those facts were that the prosecutor had, in fact, investigated whether there was a third tape. She had found that there was no third tape, and she had reported that to him and told him that he could investigate the issue himself. Without those 3 facts mentioned in his motion in limine, it's not a defensible opinion, and it actually is sanctionable. The panel also pointed out to this court's decision in Marshall, which talks about whether or not you have a reasonable factual basis for making statements regarding the integrity of a judicial officer. And again, the panel found he did not have a reasonable factual basis to say that the prosecutor was fully aware of exculpable conduct in light of those 3 facts that he failed to raise in his motion in limine. In connection with the McKibben matter, he also says the panel did not consider the evidence from Mr. Rick Bruner about the propriety of this stipulated consent judgment based on a local rule. But in fact, again, the panel did consider that evidence and rejected it when they said that Local Rule 25.01 did not provide a basis for respondent to file the stipulated consent judgment. And I want to address something else that the respondent said. He indicated that the magistrate told him to file the consent judgment. That is not the case. The testimony shows that he drafted it. He sent it to the magistrate and to the other defense counsel. Nobody responded to the emails. Without getting consent, he filed it anyway. Then, when he was told by Mr. Story that he did not consent, he refused to withdraw it. Not only did he refuse to withdraw it, when defense counsel had to file a motion to vacate, he opposed the motion to vacate. The panel considered that evidence and properly rejected it in finding, with clear and convincing evidence, that he had committed these rule violations in connection with count 4. I want to clear up a little bit of confusion on counts 1 and 2, though, as well. I understand that the respondent has acknowledged those rule violations, but there have been some misstatements of the facts and the testimony that was entered in this case. With respect to the Cracknells, he entered into a $100,000 loan with his client. The agreement that they entered into, although it was never in writing, said that he would pay them 10% interest, and he initially indicated that he would pay them back within a year. He did pay them some interest payments that totaled about $17,000, but it was only after the grievance was filed that he finally entered into a settlement agreement to pay them $40,000. The Cracknells never asked to have the desk returned. That was something they had given to him as a gift because he was a family friend. He took it upon himself to return it to them. And the appraisal that he mentions was never entered in the record. The only mention of appraisal suggests that the desk was worth maybe a couple $1,000s.
Who said it was worth a couple $1,000s?
That was what the respondent told the Cracknells when he returned it to them.
So how did we get a couple that lent him $100,000 at 10% interest to settle for ostensibly less than half of that?
Right, because they wanted to be done with the matter. The respondent had been a good family friend, and by giving him this money, it had strained their relationship and actually caused a rift in some of the other family members, and they just wanted to be done with the matter. And it had actually been over quite a long period of time. They loaned him this money back in 2008, 2009, and it wasn't until 2015, during the course of this grievance process, that they finally settled with him. They just wanted to be done.
So there is no certified appraisal by an expert that would say that this desk is worth in excess of $50,000?
Not in the record in this case.
All right.
So in looking at the conduct as a whole, the relator believes that an indefinite suspension is warranted, and the case law cited by the panel in its report demonstrates that. The theme in those cases fits the facts in this case: a troubling pattern of dishonest conduct and self-serving explanations that call into question a lawyer's character and integrity. And while the panel credited his lack of a disciplinary record, those cases also point out that pales in comparison to the aggravating factors and misconduct in this case. The purpose of this disciplinary process is to protect the public and to ensure that a lawyer is worthy of their trust and confidence. And this court has said numerous times, there's simply no place in the legal profession for a lawyer who is unwilling or unable to tell the truth with his clients, the courts, and his colleagues. And in this case, the respondent has blamed his clients, his colleagues, and the court for all of his misconduct. And it's for this reason that the relator believes an indefinite suspension is warranted. And that is why we ask this court to impose that sanction.
So how do you weigh the fact that he is a former assistant disciplinary counsel? He prosecuted lawyers for their breach of the Code of Professional Conduct, and he wants to use that as a mitigation, but he doesn't want to be held to a higher standard. Am I right on that?
What came out during the course of the grievance investigation is that it was believed that we wanted to impose a stricter sanction on him because of his role as disciplinary counsel and the fact that he holds himself out as a legal expert. We're not asking this court to use that as a reason to give him a more strict sanction. But it's something that this court needs to consider, again, when it goes back to the primary purpose of this disciplinary process. How can we ensure that the public can trust that lawyers are honest if we are not sanctioning those lawyers who are not honest?
Thank you.
Thank you very much.
Counsel, you've saved about a minute.
Thank you, Your Honor. I have no rebuttal.
All right. All right, thank you. We'll take the matter under advisement, and you'll be notified of our decision. Marshal, we call a recess.